All right. Good morning, everybody. Welcome to the 8th District Court of Appeals virtual courtroom. This is the case of Anthony Viola versus the Cuyahoga County Prosecutor's Office. Counsel, please remember first off, if you have any problems with your audio or video, please gesture or let the court know and we will deal with it accordingly. And when you're not speaking, please remember to mute your microphone, okay? Having said that, hear ye, hear ye, hear ye. This session of the Honorable Court of Appeals of the 8th District is now open pursuant to adjournment. The Honorable Anita Laster-Mays presiding.
Thank you, Mr. Wright. Good morning, everyone, and welcome to the Ohio 8th District Court of Appeals virtual courtroom. The rules are the same as if you are actually inside of our courthouse. Each side will have 15 minutes to argue. If the appellant, if you would like time for rebuttal, please let me know at the beginning of your argument. And we do ask that each party please state their name before you begin your argument for the panel. And at this time then, appellant Viola, you may begin.
Good morning and thank you. I would like to reserve 2 minutes of time for rebuttal.
2 minutes, thank you. Okay, you may begin.
Senior Assistant Ohio Attorney General Dan Caceres stated under oath that he used his personal Yahoo email account affixed with his official government signature to conduct official business. Yet the Cuyahoga County Prosecutor, where Caceres formerly worked, has refused to search that email account and produce releasable public records. The emails that were requested were between Mr. Caceres and government witness Catherine Clover. The county prosecutor did produce 600 pages of official emails between Caceres and Clover from his government email account, but refused to search the Caceres Yahoo account, a position that was upheld by the Ohio Court of Claims. Now, the factual record of the trial court establishes several things. One, Catherine Clover testified as a government witness in a dozen criminal cases. Two, Mr. Caceres prosecuted me and hundreds of other citizens through a multi-jurisdictional task force. Three, the United States Attorney's Office in Cleveland has stated in writing that Ms. Clover committed perjury during her testimony. And four, a series of individuals have come forward and stated in writing or under oath that Caceres had a romantic relationship with Ms. Clover that lasted several years.
Excuse me, Mr. Viola, let me ask the portion, I guess it's two questions, where they stated she committed perjury. Was the perjury related to the emails? Mr. Caceres, if you can keep your camera off, thank you. Was the perjury related to the alleged emails from the prosecutor's office? And then also, when you stated in general that he used his personal email for business, did he state that he used his prosecutor's email for business or only the attorney general's email for business? So those are my two questions.
She committed perjury during her trial testimony. That's number one. Number two is the use of the Yahoo email account for official business took place both when he was employed by the prosecutor's office and at the Ohio Attorney General's office.
Okay, and the trial testimony that she committed perjury, it wasn't related to these emails. It was for her trial, correct?
It was at my trial, and these emails concern the relationship between Caceres and Clover.
Okay.
Now, under Ohio Revised Code 274375, the requester has the burden of proving entitlement to relief. And we argue that we met our burden by providing the Ohio Court of Claims with evidence sufficient to require searching the Caceres Yahoo email account. Now, that proof is on the record. It includes the following. One, in the production of official emails, the Cuyahoga County prosecutor produced emails forwarded to and from the Caceres Yahoo email account. And these emails are on the record and were filed with objections to the magistrate's report and indicate that the county prosecutor controls or possesses at least some of the Yahoo emails. Secondly, we have affidavits from numerous individuals who saw the emails and claim there's hundreds of other Yahoo emails between Caceres and Clover. Three, we were able to obtain through a Caceres family member one Yahoo email between Caceres and Clover that contains his official signature as a prosecutor. That was provided to the court. And in his own sworn statement to the Ohio Court of Claims, Caceres acknowledges using his private Yahoo email account to conduct official business, and that he forwarded and deleted emails to the prosecutor's office and from his Yahoo account. Taken together, these facts confirm that Caceres integrated his personal Yahoo email account with an official signature with his government email accounts to subvert the Ohio records laws and create a back channel means of communication with Catherine Clover.
So, Mr. Viola, I have a question. How do we have the safeguards to make sure that the floodgates aren't open for a fishing expedition into private emails?
Well, the question we believe is this: can a prosecutor have a private email conversation with a government witness? And if so, those would be subject to exemptions or redactions. But the failure to even search the account is the issue in this case. See, we believe, pursuant to Ohio Revised Code 14943B1, that we pled facts that is sufficient enough to argue that the account should be searched. We're not saying that all Yahoo emails sent by Mr. Caceres with his official signature are public records, but we're saying that the account should be searched to determine whether or not they're public records.
And searched by who?
The Cuyahoga County Prosecutor's Office. And let me give you some public interest considerations. I mean, I was tried twice on identical charges and was acquitted at a second trial using evidence that the prosecutors did not produce before the first trial. And this Ms. Clover testified in a myriad of cases. And the official emails that were produced by the county prosecutor should greatly alarm this court. They're on the record. Clover was portrayed as a fact witness, coming into court just telling what she knows. But in fact, she attended meetings with other government witnesses. She's writing indictments. She's writing bills of particulars. She's revealing grand jury information. There's racist emails. Caceres and Clover are talking about dressing up, quote, like an African or like Orthodox Jews. They're talking about, quote, taking down Tony Viola. Caceres writes a resume for Clover that says she works as an employee of the prosecutor's office. There's, in the emails that were produced, there's complete awareness that Clover committed perjury at the first trial. And yet there's no discussion of withdrawing perjured testimony. They're covering it up in these official emails. And lastly, in late 2020, Ms. Clover's attorney, Jay Schlackett, he admits that Clover destroyed evidence inside the prosecutor's office, but claims she only did it to help herself. So how a criminal defendant is accessing evidence inside the Cuyahoga County prosecutor's office, being portrayed as a fact witness, the government later says she committed perjury. This entire matter should greatly alarm this court, and these emails should be made public. And in fact, let's just talk about some of the violations of the law that we have here on this record that don't require any speculation. First of all, this is a clear Brady violation. These emails should have been produced before trial. The relationship between Caceres and Clover should have been produced before trial. I can assure you, Mr. Caceres would have been called as a defense witness. We have a Giglio violation with undisclosed benefits to a government witness, the failure to withdraw perjured testimony, violation of Ohio Revised Code 149.351, which prohibits the destruction and damage of public records. We've got a violation of the rules of professional conduct by Mr. Caceres by having an inappropriate personal relationship with a witness, which is a conflict of interest. Rule 8.4, engaging in conduct prejudicial to the fair administration of justice. And attorneys representing the government should have reported this misconduct. Mr.
Viola, what does all of this laundry list of potential violations that you're accusing the Cuyahoga County Prosecutor's Office and I guess others of committing, what does that have to do with the question before us, which is, I think, whether the decision by the Court of Claims is supported by the evidence in the record?
Right. Our argument is quite simply that the Court of Claims ruling should be vacated because we met our burden of proof. We met our burden to clearly establish the high likelihood of the existence of public records on this Yahoo account, some of which are in the possession of the Cuyahoga County prosecutor. And we believe there's a great...
In that regard, I want to direct your attention back to the statement you made earlier that Mr. Caceres had stated in an affidavit that he used his personal Yahoo account for both work at the Attorney General's office and work at the County Prosecutor's office. And I'm wondering if you could direct us to two things. Number one, could you direct us to where that is in the evidence? And number two, what is your response to the County Prosecutor's office assertion that in fact Mr. Caceres's statement is more narrow and that he had admitted only to have forwarding some work emails to his home account?
Well, first of all, the Caceres affidavit was filed by me as part of objections to the magistrate's report. It is on this record. And it was also filed in a motion for judgment in this matter. So these affidavits that I mentioned about the romantic relationship between Mr. Caceres and this witness, and these witnesses have come forward and sworn that it's true under oath, are all on the record. And taken collectively, they indicate that there's a high likelihood that the government possesses records or there are public records that have not been produced. Now, I mean, your question about the laundry list is this is a records case. And the records laws are designed to make transparency the hallmark of government. But if someone can use a private email account with an official government signature and then say, well, I searched it, there's nothing there. And then any politician who doesn't feel like following the records laws can just simply use a private account. You know, the courts have held that just because something is on a private email account doesn't mean it's not a public record. And we argue that an email between a prosecutor and a government witness implicates the core function of a prosecutor's office, presenting cases in court, testimony, resolving criminal matters. So I argue that they are likely public records, but at a minimum have to be searched. And our burden was to establish the existence or the likely existence of public records, which we met. And even if Mr. Caceres only used the Yahoo account a little bit, he's admitted doing it. And we also have a Yahoo email that's salacious between him and Ms. Clover. So in terms of the ruling of the Ohio Court of Claims, we argue it should be vacated because we met our burden of establishing the likelihood of public records. And in terms of this misconduct, we have an untenable situation where a private citizen and my investigative team is conducting an investigation into criminal activities by Mr. Caceres. This is wholly inappropriate. The reason that the Ohio Supreme Court has established that Rule 8.4 is so that attorneys who become aware or of credible allegations of misconduct refer to the appropriate authority for a proper investigation. And that's what should happen in this case. The Court of Claims decision should be vacated and this should be remanded back.
Thank you.
Thank you.
Are there any additional questions? You have 3 minutes and 24 seconds, so you haven't gotten into your rebuttal, or do you want to save that time?
No, I can just add one other point about public interest considerations.
Okay.
Which is, I was tried twice and acquitted at a subsequent trial using evidence that the Cuyahoga County prosecutor did not produce before the first trial. And that evidence was provided by a whistleblower inside the prosecutor's office named Dawn Pasella. Mr. Caceres had directed her to wear a wire and pretend to be a graduate student studying criminal defense. But she was actually recording a series of post-indictment conversations with me to obtain confidential defense trial strategy information. And when Ms. Pasella came forward to assist me, she also offered to testify at the second trial about the Caceres-Clover affair because she was in the prosecutor's office so much, and about the hiding of exculpatory evidence. But when Mr. Caceres found this out, he threatened her. He went to her parents' house. He went to her apartment. He threatened to put her in jail. And Ms. Pasella never made it to court. She was found dead in her apartment by her father the day she was supposed to testify. And no investigation into this tragedy has ever taken place. And let me say that Dawn Pasella told me that the evidence she gave me was not specific to my case, that she felt it undermined all of these mortgage fraud prosecutions, and that the cases Catherine Clover testified in should be reopened because of this romantic relationship. So we argue there's great public interest here, and the decision by the court in my case may affect up to 1,000 other individuals who were prosecuted by this multi-jurisdictional task force.
Okay, now you're going into your rebuttal. Okay, all right, thank you.
Judge Mays, can I just ask one quick question? Because I
Yes.
need to understand the information that you just provided. How I don't understand how that can be considered in our deliberations.
Because the emails that were produced in the
No,
official,
I'm talking about this extra information that you just provided. I don't know how appropriate it is for us to consider. We're to consider only things that are in the record.
these are all in the record.
The information you just provided about the death of the person, is that information in the record?
If it's not, I can ask you to take judicial notice of case
No,
15
we
CV
can't take-
242.
we can't.
Okay.
No, the court can
Okay.
we can only make our decision based on information that is in the record. So the
Right, and what
information
was
that
said,
you
the
just-
court of claims, yes. Mhm.
Thank you. And I want to clarify that too for you, Mr. Viola. I think it's inappropriate for us to consider, it is inappropriate for us to consider things that are not in the record and for you to discuss things that are not in the record.
Okay, thank you. Okay, so you'll still have your full 2 minutes for rebuttal. Okay, appellee attorney Elliott.
Hey, I'll begin.
Yes, you may begin.
Good morning, Your Honors, and may it please the court. My name is Jake Elliott, and I represent the Cuyahoga County Prosecutor's Office in this public records matter. And that's what this is. It's a public records case. Even Viola, in his brief, puts the issue before the court as, quote, the use of a private email account to engage in official business by a public official. Very little of what Mr. Viola has presented this morning, as well as in his briefing, is relevant to whether the Court of Claims erred or whether and whether Viola met his burden to prove by clear and convincing evidence that prosecutor's office records, public records, exist on former assistant prosecuting attorney Dan Caceres' private email account. Judge Groves mentioned the floodgates that could potentially be opened, and the protection from that is the burden that's on Mr. Viola to show by clear and convincing evidence that records do exist. Viola requested that the prosecutor's office find records on a private Yahoo email account that was maintained and is still maintained by this former assistant prosecuting attorney Dan Caceres. The prosecutor's office maintains that it can't search those files, and it's not obligated to without Viola meeting his burden. This is without going into how that search might even be conducted. Ostensibly, Viola's reason is the presence of a signature block on Caceres' private emails that identify him as an assistant prosecuting attorney. The prosecutor's office originally moved to dismiss this case and brought a supporting affidavit by Caceres that says there was no recollection of Caceres ever using his private email account for prosecutor's office business. Nevertheless, he claims that he searched anyway and that the documents don't exist. This is, again, contrary to what Mr. Viola has stated, that there is an affidavit swearing under oath that Caceres used his his private email account for official business.
So let me ask you, how do we ensure the integrity of that response? Are you indicating that the reliance should be on Mr. Caceres saying, hey, I did not use, I don't recall? Because on the flip side, how do we make sure that the usage of private emails for business cannot be utilized to like shield from public view certain conversations that perhaps should be subject to public scrutiny if we're just going to rely on that person's email, that person who says, I don't think I use my email for business usage?
Yeah, respectfully, Your Honor, your question sort of flips the burden from Mr. Viola, the requester, onto the prosecutor's office. It's not up to the prosecutor's office to establish that records don't exist. And I think the special master got it right when he said that this was some evidence that records do not exist on the private email account. But the important thing to remember is that it's up to Mr. Viola to show, and he's managed to get a hold of some of these private emails, and those are in the record. So the idea that it's a shield is a little bit misguided in the sense that it pushes the burden away from the requester and back onto the respondent. And sort of following up with that, the special master reviewed all of those documents that Mr. Viola submitted, as well as that affidavit, and found that he had not met his burden to recommend dismissal. And the Court of Claims got it right. Despite all of the records that Viola has presented, and the story that he's presented to the court that's extraneous, he's failed to show that the records he seeks were maintained on this account. He's presented a lot of material that show salacious things, snippets of social media conversations. But what he does not do is establish by clear and convincing evidence that records exist on this private email account. The other reason that the Court of Claims opinion should be affirmed is that it correctly determined, contrary to Mr. Viola's assignment of error, that a signature block is not sufficient to render all documents above that signature block public records. Just to be clear, the prosecutor's office doesn't contend, obviously, that an email can't be a public record. The prosecutor's office provided 572 pages of emails from its official public server that were sent to and from Mr. Caceres and others. And it doesn't even contend that a private email cannot be a public record either. I mean, I think the case law is pretty clear on that. Gupta suggests that a public record could exist on a private phone. Also, I believe it's McCaffrey suggests that text messages. Glasgow also addresses text messages. These are private, private devices that may contain public records. That's not the issue here. The issue here is the burden and whether or not Viola has met that burden. If he had and had shown that private records had existed, then the prosecutor's office would have to figure out a way to get these documents off of this private email server, and that would be a whole new problem.
Let me ask this question.
Yes.
I think Mr. Viola stated that the prosecutor's office in those 500 emails, one email showed some communication from his private server to Ms. Clover. Wouldn't that one give rise to then there's maybe more if you did a different search?
Yes, I think that would be true if the underlying factual basis for what Viola claims was true. One of the things that he sort of glossed over or hasn't recognized is that the to from CC blocks of all of these emails are unredacted. It shows exactly who received what email and who sent.
Okay, that was my next question. Were anything redacted, or was it like an in-camera inspection or anything? You just gave them what you had.
Certain documents were redacted, reflecting attorney-client work product and that sort of thing. And Viola hasn't objected to the redactions whatsoever. But again, even on those emails where the content of the email was redacted, to whom it was directed and to whom and who sent it are both unredacted and can be identified easily through a quick review. There is the email that he's directed the court to. I don't know the exact page on the record, but it is redacted. It is a redacted email. The content of the email is redacted. At the bottom of the email is an unredacted section that says something like "sent from my Yahoo phone" or something to that effect. And Viola takes that piece and has assigned value to that particular bit of information that is simply not true. I'd like to go back to the affidavit and address that briefly because Viola's assignment of error actually addresses it directly. The assignment of error states that Mr. Caceres under oath stated that he conducted official business, and that's true. What's not true is that he stated that he conducted official business of the Cuyahoga County Prosecutor's Office. There were a number of public records requests submitted sort of simultaneously to Caceres, and this is in the record. The Caceres affidavit related to the prosecutor's office says that he doesn't recall ever using his email for Cuyahoga County Prosecutor's Office business, that he searched it anyway, and that he was unable to find responsive public records. The affidavit to which Mr. Viola refers as Caceres admitting that he has conducted official business was related to a separate public records request, an affidavit that states that, quote, on very rare occasions, Caceres used his email account to forward or move emails from in his duties as an assistant attorney general, a position that he was hired to long after Viola was prosecuted.
Mr. Elliott, while we're focusing here on what the documents do show, this discussion of the use of an official signature block, and you referred to it a moment ago in your comments. The use of an official signature block alone does not convert a document into a public record. And I'm where is the line then? What is the prosecutor's office? What is the prosecutor's office position on where the line is? What does convert a private document into a public document if it's not enough to just have your official public officer signature block on the document?
Sure. I think the answer is found within the definition of what a record is in 149.011G. Again, we're not it's a three-part test. The relevant issue here is whether, once you've established that it's a document and that it may fall under the jurisdiction of the public office, does it document the organization, functions, policies, decisions, procedures, operations, or other activities of the public office? And that essentially what needs to be evaluated isn't whether or not a person identifies themselves as a public official. That doesn't get you very far. The content of the communication, the content of the document is the important consideration. And case law shows that this is, it's been repeatedly evaluated this way. In the case of the city of Blue Ash, for example, there were inter-office emails sent as an individual assessment of supervisors, how their supervisees were evaluating the supervisor's performance. It's part of an individual development task, and those assessments were circulated within the public official servers. The court found that the lower court inappropriately issued a writ requiring the city to produce those documents. Another example is found in the Wilson Simmons case. wherein a racist email was circulated again on by a public official on the official's email server. And the court found that that did not document the duties and responsibilities of the office. So even, here we're sort of once removed even from that. We're not even dealing with official servers, official public officials sending these documents. We're in a personal email capacity, and the content is what matters. So the signature block is just, it's almost a non-starter. Every email needs to be evaluated for its content, and to say that the signature block would be sufficient would sort of undermine the test of what a record is under the statute and as established in the Supreme Court's case in Glasgow. Essentially, what we're left with here is just speculation by Viola as to whether or not these documents might exist and whether or not they might be public records, which is simply insufficient for Mr. Viola to meet his burden. And if there's no other questions, I have nothing further.
Okay, any other questions? No? Okay. Thank you. You finished with 26 seconds left. Okay, thank you. Okay. Setting my clock, Mr. Viola. Okay, you have your 2 minutes. Thank you.
Well, I agree that the content of the emails matters more than the signature block, but the county won't search the emails, so we don't know what they say. So I agree with Mr. Elliott. Each email needs to be evaluated. We met our burden. 4 ways do we meet our burden of establishing that there's emails that should be searched. 1, and there's several of them, and they're filed with objections to the magistrate's report. Underneath the official emails, it says sent from Yahoo. And so we're arguing that the Caceres Yahoo is integrated with the county prosecutor's office email, and they possess and control them. 2, we've got affidavits from multiple individuals that say they saw these emails. 3, we've got Caceres' own sworn statement that says he used the Yahoo for official purposes on some occasion. And 4, we have a Yahoo email. We have one, and it doesn't matter that it's salacious. The issue is that it exists, and that helps us meet our burden. A communication between a prosecutor and a government witness implicates the core function of the prosecutor's office, and it's likely to be a public record, even if he's just saying good morning. That should be a public record. And what was produced by the county in the official email should greatly alarm everyone here, and it bolsters the public interest in having the Yahoo account searched. We're not saying every Yahoo email with a government official signature is public record. We are saying that we met our burden. We introduced substantial evidence to show that there's a likelihood of records that exist and they should be searched. And the remedy the court can grant after 10 years in jail is transparency. And it's then the public's right to know. The public has an interest in the fair administration of justice, and that would be achieved by remanding this case back to the Ohio Court of Claims for further proceedings. Thank you.
Okay, thank you. This is a great argument, interesting facts and interesting issues. And we will get a decision out to you as soon as we possibly can. This matter will be marked heard and submitted. And I'll turn it back over to you, Bailiff Wright.
Right. Hear ye, hear ye, hear ye. This session of the Honorable Court of Appeals of the Highway District is now adjourned. Everyone have a great day.
Thank you.
Thank you
That's
for
all
the
I'm about to say.
opportunity.
You're
Thank
welcome.
you for the opportunity.
Have a good afternoon. Thank you.
Very grateful for the opportunity. Thank you.
No problem. Mhm.